Good afternoon. For those of you who don't know me, my name is Stuart Rudner. I'm an employment lawyer and mediator, founder of Rudner Law. And on behalf of the entire team at Rudner Law, we'd like to welcome everyone to our fall webinar, which has been titled Navigating the Hopefully Post-Pandemic Workplace. We try to be really cautious about these predictions because, as some people remember, our very first guide to returning to the workplace after COVID was first published in May of 2020. And if you don't believe me, there is a proof of it. So we're trying to be cautious, but we are hopeful, despite the fact that there are now renewed calls for mask requirements or recommendations, if not requirements these days. So we're hoping that we are not going back to where we were. That being said, we have had 2.5 years of massive changes around the world and in the workplace. One of the positive results, I'll say, of the pandemic has been the widespread reassessment of the role of work in our lives and the nature of the workplace. We're no longer assuming that we have to get up at the crack of dawn, commute to work all day, commute back home, and then start our quote unquote personal time. We're reconsidering where we work, when we work, and also the interaction between work time and personal time. And we're not talking so much about work-life balance anymore as we are talking about work-life blending, which I think for many of us makes a lot more sense, and not necessarily ensuring that we stop work at 5 p.m., but being able to go pick up the kids around 3:30 and perhaps working a little bit earlier in the morning or later in the evening, and having that blending as opposed to the hard and fast cutoffs. And it was interesting for those of you who saw the recent survey, it just came out earlier this week from Maru Public Opinion, that showed that 71% of workers say that workplace flexibility, which includes remote work, is a key factor when looking for a new job. So this is not something that's going to change. And it creates pretty significant changes in the world of HR law. So when you add that to the ongoing evolution of the common law, and we'll be talking about things like termination clauses and post-termination compensation, and some significant legislative changes that we're going to hear about, there is never a dull moment in the world of HR law. I've been practicing HR law for over 23 years now, and I haven't seen anything like the last couple of years. So we wanted to take some time today before the holidays just to give you guys an update on what you should be aware of as you go forward, including things you should have been aware of already, but I want to make sure you are addressing them properly. And we're going to try to leave some time at the end for at least a few questions and answers, so you can use the Q&A box if you have any questions you'd like us to address. But I want to have time because all of the lawyers within the firm are going to be doing their own sections today, so I want to make sure everyone has the time to do that, answer for some Q&A, and get everyone out of here or virtually out of here at 1 o'clock so you can go back to your days. So with that, I'm going to go on to the next slide, which we've already looked at. And then to make sure you are aware, because we are lawyers, there must be a disclaimer. So just a reminder that this presentation is for information purposes only, does not constitute legal advice. You should get proper legal advice for your specific situation if you have one. And also to remind you, just because life changes so quickly these days, that the information we're sharing is current as of November 2022, but should not be relied upon in the future without checking with us. And lastly, that these materials should not be reproduced. On that note, if you would like a copy of the slide deck, then feel free to email us and we'll be happy to share that with you. So this is the agenda for today. And as you'll see, first up, Nadia Zaman gets to do double duty. First of all, talking about back to the office / remote work / hybrid work, and then also talking about pivoting. And I know she's got a couch image in there, so I'm sure she'll explain what the couch has to do with pivoting. So Nadia, I'll let you take it from here.
Thanks, Stuart. Now, with respect to this topic of back to the office, remote and hybrid workers, it's probably one of the biggest challenges employers and employees face since the pandemic and are still facing currently. Stuart, could you move to the next slide? Thank you. So you may be an employer that wants people back in the office, but employees just don't want to return. Or you may be an employee who's working perfectly fine from home and is suddenly being required to attend the office in person. Now, one of the common questions we get from employers and employees alike is, can employers force employees back to the office? The answer, like most answers in employment law, is it depends. There, I use the dreaded phrase. Generally speaking, employees cannot refuse to return to the office unless they have an existing right to work remotely. They're refusing unsafe work. They have a legitimate need for accommodation based on a protected ground under human rights legislation, such as disability, or if they're on a leave of absence. What does this mean in practice? Well, let's say you're an employer and have allowed your employees to work from home during the pandemic. Suppose there was no communication regarding expectations to return to in-person work in the future. The risk is that the right to work from home may have become or may become entrenched at some point. There's no hard and fast rule about this. However, we have helped many of our employer clients avoid circumstances where they lose the ability to dictate where their employees will work from simply due to a lack of proper communication and documentation. We have helped our clients effectively communicate expectations so that it's clear remote work is temporary and that the organization expects to have employees back in the office, even if on a hybrid model in the near future. Effective communication and documentation are your best friends to maximize your rights and flexibility, as well as minimize potential liability. And we help you to do that. Employers must also be mindful of the potential need for accommodation. Employers are obligated to accommodate an employee's legitimate needs based on a protected ground under human rights legislation, such as disability or family status, but are not obligated to accommodate an employee's preference. Employers are only obligated to provide a reasonable accommodation. So if work from home is the only reasonable accommodation under the circumstances, then the employer can't force the employee to return to the office. However, if it's simply the employee's preference, then an employer can impose return to the office. Of course, there are practical considerations as well, such as retention of talent, and a lot of employees nowadays are prioritizing remote work. We help both employers and employees navigate the accommodation process to ensure they meet their legal obligations and get what they're entitled to. Stuart, next slide, please. Now, what are the options for addressing a work from home request? You can either have a hybrid work model where you alternate between remote and in-person work, or a purely remote work model, whether temporary or permanent. We help both employers and employees deal with such requests and navigate the arrangement so that they can be strategic without sacrificing their rights. Stuart, next slide, please. So what are some considerations to keep in mind when it comes to remote work? First and foremost, remember that employment relationships are legal relationships. Make sure to put arrangements in writing before remote work starts. And this is not only limited to having effective contracts in place, but also ensuring that you have a remote work policy. Secondly, consider the employee's work location. If the employee is working from home and they're located in a different province, the laws that apply may be different. Even if it is within Canada, each province has its own employment standards legislation with various nuances. If you're not careful, then you may inadvertently breach the statute and be on the hook for liability. Also consider what equipment is required for the remote employees to be able to do their job from home. Who provides and pays for what? Consider health and safety in a remote work environment. And last but not the least, consider how you will manage remote employees. How do you ensure people are working from home properly? Part of it is the electronic monitoring policy, which will be discussed in more detail later. If you have nothing in writing regarding remote work and your expectations as an employer, then recalling employees back to the office may constitute a constructive dismissal of their employment, which means you could be exposed to substantial liability amounting to up to 2 years of pay. This is why we're big proponents of ensuring proper contracts and policies are in place to protect employers from liability. Now, this is a good segue into the next topic. Stuart, next slide, please. I'm going to be talking about pivoting without constructive dismissal, and the reference to the couch for those of you who have watched Friends We'll remember that episode where Ross Geller tries to move a new couch up these winded stairs with Rachel and Chandler. And it was a really bad decision because it was just next to impossible to maneuver that. And the reason why he did that was because he didn't want to pay the delivery fee. So the moral of the story, as you'll see, is that it's not really wise to be penny wise and pound foolish. He should have just paid for the delivery fee and avoided the whole hassle. Obviously, then we wouldn't get the entertainment factor there. Next slide, please. Before I get to pivoting, it's important to briefly state what's constructive dismissal. A constructive dismissal occurs where there is a unilateral and substantial change to a fundamental term or condition of employment. This includes, but is not limited to, changes to compensation, schedule, duties, work location, and so on. A constructive dismissal can occur even if an employee's compensation does not decrease, and it can be caused by a failure to provide a healthy and safe work environment, including a failure to address harassment or bullying. The result is the same as an outright dismissal, so the employee will be entitled to damages as if they had been dismissed outright. Employers may also be exposed to additional liability if they were found to have engaged in bad faith conduct. Stuart, next slide, please. So how do you make changes as an employer without attracting constructive dismissal claims? How do you pivot without attracting constructive dismissal claims? Remember that employment relationships are legal relationships, so you should use contracts and policies strategically. First, flex your discretion muscles. Ensure your contracts give you flexibility to make changes. Include wording in the contract clearly giving the organization discretion to make changes and noting that it will not constitute constructive dismissal. We regularly work with employers to ensure they have strong contracts in place, giving them the flexibility to effectively manage their business while complying with the law and reducing liability. We also help employees review employment contracts and advise them and help them negotiate with their employers. Second, get written consent for changes. If the employee agrees to the change, then it is no longer a unilateral change and thus not a constructive dismissal. Alternatively, give appropriate notice for changes. The appropriate notice would be equivalent to the notice you would be required to give for termination as an employer. We regularly help both employers and employees through this process, whether it's through negotiation or litigation. And finally, seek legal advice from an employment lawyer before doing anything that may have legal implications. As we always say, if you think you need an employment lawyer, you probably do. And that's all for me.
Great, thanks, Nadia. And I love the couch analogy and the point that it often does pay to get a professional involved instead of doing it yourself. And I love a brand new way to make that point. So thank you, and thank you for using or at least one of our favorite catchphrases. If you think you might need an employment lawyer, you probably do. So next up, we have Alex Minkin, and of course, it wouldn't really be an HR law discussion without talking about a topic that is near and dear to my heart, which is terminations. So despite the fact that the courts were closed for an extended period of time in 2020 and 21, and despite everything else that's been going on, we have definitely had some developments and significant developments in the world of terminations and post-termination compensation. So Alex, I will turn it over to you.
Thanks, Stuart. So I'm going to be providing an update on the recent case law regarding terminations, and I'm going to be focusing on two topics. The first is the law on termination clauses in employment contracts, and the second is how compensation is calculated during the applicable notice period. So when we're talking about termination clauses, the general rule in employment law is that any employee that is dismissed without cause is entitled to reasonable notice of termination pursuant to common law. The exception to this is if there's a properly drafted and legally enforceable termination clause. that can displace the employee's entitlement to common law notice. The employee must always be provided their statutory minimum notice in accordance with the Employment Standards Act. And a termination clause that provides for anything less than the minimum statutory notice will be unenforceable. If the contract is unenforceable, if the termination clause is unenforceable, the employee will be entitled to common law notice as if there wasn't a termination clause. Now, whether a termination clause is valid and enforceable is a question for the courts to consider on any particular case. The law on termination clauses is constantly evolving, and it's very clear that the movement has been towards the side of employees. That means that more termination clauses are being held to be unenforceable. The most significant case on this topic in recent years was the case of Waxdale, which was released in June of 2020, which found that a with cause termination provision that violates the Employment Standards Act invalidates the entire termination clause. This was very significant because it applied to a large number of employment contracts. One thing we often see is that if a contract was drafted before June of 2020, there's a high chance that it will violate that rule and will be found unenforceable on that basis. So when we're representing employees, we're looking for ways to attack termination clauses and argue that they're being unenforceable. When we're representing employers, we try to encourage our clients to fix their termination clauses by entering into new contracts with employees, either by providing working notice of the changes or by providing consideration in the form of a signing bonus or other payments. Now, in last year, in 2021, there was the case of Rahman, which appeared to be pro-employer. It appeared to represent the pendulum swinging a little bit in the other direction when it comes to termination clauses. In that case, the court ruled that a termination clause was valid, was enforceable, and in doing so relied on the sophistication of the party, of the employee, and relied upon the independent legal advice that she received. However, that decision in May of this year, May of 2022, the Court of Appeal overturned that decision, found that the employment contract was invalid, was unenforceable for the same reason as the Waxdale decision, and specifically found that the sophistication of the employee and the legal advice that she received was not relevant in making that determination. So we expect that this area of law is going to continue to evolve. But for now, the movement is clearly on the side of employees. So both employees and employers should be aware that old contracts might not be valid. And even if a termination clause limits what an employee is supposed to receive upon termination, that clause might not govern. They might be entitled to common law notice. So I'm going to now talk about common law notice, and common law notice is essentially the reasonable amount of time it should take the employee to obtain replacement employment. What the Court of Appeal says is that damages for wrongful dismissal represent all losses arising from the employer's breach of contract in failing to give reasonable notice. So this is essentially what it is it's equal to the amount the employee would have earned during the notice period if their employment had continued, minus the amount of mitigation income that they earned during that period. So if we look then at the compensation that an employee is entitled to during the notice period, if we can turn to the next slide. By default, this is not limited to base salary. The Court of Appeal clarified this includes benefits, this includes pension payments, it includes bonuses, stock options, and other incentives. It essentially includes all of the compensation the employee would have earned if they had been given working notice and continued to be employed as before throughout the notice period. So of course, this can be limited by an employment contract, as we discussed before, but it can also be limited by an applicable plan. For instance, an entitlement to bonus can be limited by a bonus plan, or an entitlement to stock options can be limited by a stock options plan. And in the case of Battison, which was a Court of Appeal decision in October of 2021, the Court of Appeal ruled that the terms of the applicable stock option plan meant that the employee was not entitled to stock options that would have been vested during the common law notice period. So a plan like that can in some case limit the employee's entitlements. Now, I'm going to talk about two other cases that came this year that have to do with this topic of the compensation during the notice period. The first is the case of Bowen. This came out in August of this year, and this dealt with an issue of a discretionary bonus. The Court of Appeal found that a discretionary bonus could not be withheld arbitrarily, and that the employee in this case was entitled to the discretionary bonus during the notice period. This is, of course, significant because we see a lot of bonus plans use discretionary language and indicate that there's no specific entitlement for the employee to receive it, that it's all discretionary. But in spite of this language, the Court of Appeal found that the employee in this case was entitled to the discretionary bonus during the notice period. The other case that I will mention is the case of Ruel and Air Canada. This was a case in which the plaintiff was about 6 months away from retiring from Air Canada and from being automatically eligible to flight privileges that are normally afforded to retirees with 25 years of service. So if they had been given 6 months of working, at least 6 months of working notice, they would have been entitled to these retiree flight privileges. The court in that case found that the employee was entitled to these flight privileges. And rather than awarding damages for this, the court actually ordered Air Canada to provide the employee these flight privileges. So specific performance of the flight privileges were granted. So it's important to know when looking at these cases, the common law notice, the damages for common law notice and for wrongful dismissal sometimes are not only limited to monetary compensation. They're certainly not limited to base salary alone. There's a wide range of compensation this includes, but it's not only limited to monetary compensation. It can include specific performance of certain benefits or certain programs. So knowing this, knowing the principles of common law notice and wrongful dismissal can be very beneficial for both employees and employers to know. And for employers, knowing these principles can help them craft a suitable termination package and hopefully reach mutually agreeable resolutions with dismissed employees without having to resort to costly and lengthy litigation. So that's all for me, and I'll send it back to you, Stuart.
Thanks very much, Alex. That was a lot to cover in less than 10 minutes, so thank you. And I have to say, I know Alex is very calm and collected when he talked about that, but we can't really overstate the significance of some of the cases that Alex mentioned and the fact that I've said this many times lately, most of the termination clauses we see are not enforceable if challenged. So what that means, if you're an employer and you're assuming that you have a clause which protects you, and maybe you're only obligated to pay 5 weeks or 8 weeks of termination pay, you could be on the hook for up to 24 months, plus additional compensation such as bonuses and et cetera. So this is dramatic. And I will repeat an offer or a challenge, depending on how you look at it, that I've made many times recently, which is if you have an employment contract template, send it to us and we will very happily take a quick look and let you know if there are any red flags. There's no cost, no obligation for that. But most of the clauses we're seeing are not enforceable. And we'd rather that people know that before it's challenged rather than after it's challenged. So please feel free to send us your contracts and we'll take a look. So that being said, we're going to shift to Brittany Taylor now, who is going to talk about new legislative requirements and also gaze into her crystal ball and look at some of the ones that are coming in 2023. So Brittany, I'll turn it over to you.
Thanks, Stuart. So as Stuart mentioned, I am here to talk about the very exciting topic of legislative updates. In all fairness, this is a very exciting topic because as Stuart mentioned, this has been an extraordinary couple of years in terms of changes coming into effect. They've been coming fast. And that's certainly been a new hurdle for employers to overcome in the last few years. So I'm going to be looking at what has changed in 2022, not just in Ontario, but kind of across Canada, and what to expect in 2023 and beyond. So let's get to the first slide. So there's two new policy requirements out of Ontario that I want to talk about. The first is the disconnecting from work policy. This policy requirement applies to employers with 25 or more employees as of January 1st of any given year. This year, because it was the first year that this requirement was in place, employers had up until June 2nd to prepare and implement this policy. Going forward, if you meet the January 1st threshold of 25 employees or more, it's going to be a March deadline to get this policy put in place. So just keep that in mind if you become if this becomes a requirement for you in the near future. This policy is one that was very widely portrayed in the media and misunderstood by employees as creating a right to disconnect from work. And I think that had a lot to do with the language that was when this proposal was first issued, it was described as a right to disconnect policy. But that is not actually what it does. It does not create any new rights or entitlements for employees whatsoever. What it does require is that employers have a policy with respect to disconnecting from work. What that policy must include is actually very much open to the discretion of the employer. The only requirements with respect to this policy is that it set out expectations on disconnecting from work, so very, very general in that regard, and that it has to set out the date the policy was prepared and the date that any updates are made to the policy. So other than those requirements, it is very much open to employers to determine what the expectations are and how they want to communicate them to their staff in their disconnecting from work policy. Now, one kind of pitfall or potential pitfall that we've seen employers fall into is actually accidentally creating new rights or entitlements for employees in the course of drafting these policies. So, they are inadvertently putting into their disconnecting from work policy something that says you will never have to answer emails after 5 p.m., right? When that might not actually be the case, that might not actually be the expectation that you want to set, but it could have the effect of creating that expectation, creating that right for employees to fully disconnect from work after 5 p.m. When that may be not what is beneficial for your business. So we highly recommend getting legal advice with respect to this policy in particular. We helped a number of clients draft policies that met the expectations or met the requirements, but still created flexibility and didn't really create any fundamental change in their business operations. So that's the first policy requirement, and we can move on to the second requirement, which is the electronic monitoring of employees policy requirement. This is similar to the framework of the disconnecting from work policy in that it applies to employers with 25 or more employees as of January 1st of any given year in Ontario. Again, because this was the first year that this requirement came into effect, employers had until October 11th to prepare and implement their policies. Again, going forward, that deadline is going to change to March in future years if you meet that requirement as of January 1st. This is another policy requirement that we saw a lot of misunderstanding in terms of what the purpose of this actually was. There was some suggestion that this actually restricted or limited an employer's ability to electronically monitor their staff, and that is not the case at all. Again, this did not create any new rights or entitlements for employees. What it does require is that employers are open and honest and forthright with respect to how they are monitoring staff. So your electronic monitoring policy specifically must set out whether you're electronically monitoring your staff, and if so, how and in what circumstances that monitoring is going to occur, and also what is the purpose that the data or information that you obtain through that monitoring, what is that going to be used for? Or what could it be used for? And just like with the disconnecting from work policy, we also have the requirement to set out the date the policy was prepared and the date of any changes. But other than that, no direction in term or requirements in terms of specifically what your policy has to set out. Now, one thing to keep in mind as an employer is that electronic monitoring is a very, very broad heading. We're not just talking about keystroke tracking on an employee's computer. We're also talking about things that have been around for a very long time, like GPSs in company vehicles, security cameras, key card swipe entrance and exit from buildings, phone call recordings. Those are all forms of electronic monitoring. So this is not just targeting those new forms of electronic monitoring that may have risen in light of the increase in remote work, as Nadia kind of alluded to during her presentation. So again, this is another policy that we would highly recommend that you get legal advice in terms of preparing, just to make sure that you have actually captured not just all the forms of electronic monitoring that may be happening in your workplace, but the reasons why and the potential purposes for which that information could be used. We can certainly assist you to think more broadly about that and help you draft that policy correctly. Okay, so let's leave Ontario behind for a moment and talk about new French language requirements. We don't often get to speak about Quebec. That's not really an area that we practice in because Quebec functions on a very different legal system than the rest of Canada. I will say that while we don't practice in Quebec, we do have connections with lawyers in this jurisdiction and can assist you to get the help that you need. So if you are a Quebec-based employer, please do still reach out to us. Don't feel like we can't help you. We can definitely still point you in the right direction, even if we're not equipped to personally assist you with this. So, big change out of Quebec is an amendment to the Quebec Charter of the French Language. And essentially what this new requirement is that certain contracts, specifically adhesion contracts, must be provided to employees in French first. Once that first draft of the agreement is provided to the employee in French, then the employee can agree that the parties are going to be bound by the English version, but it has to be provided in French language first. So the question, of course, on your minds right now is, what the heck is an adhesion contract? An adhesion contract is basically a contract being imposed by one party on another. So this would arise with a lot of entry-level, lower-level employees who do not have the ability to negotiate the terms of their contract. So if your kind of method with these employees is, here's the contract, sign it, take it or leave it, that's going to be an adhesion contract. Contracts with senior managers or more upper level employees where there is some back and forth, there is some negotiating power, are not going to fall within this requirement. So you should be aware of this if you are operating in Quebec, that this new requirement has come into effect, but it may not apply to all of your contracts. Okay, let's move on to talk about miscellaneous changes. So this is going to be a little journey across Canada. It's actually not. It's only 3 provinces that we're going to be talking about. I do want to highlight that this is just the tip of the iceberg. There were so many legal changes that came into effect over the course of the pandemic, not all of them pandemic related. So there is a lot more out there, but I want to focus on some key ones. The first province I want to talk about is British Columbia. So as of January 1st of this year, employees with more than 90 consecutive days of service are now entitled to 5 paid days of personal illness or injury leave per calendar year. Okay, so paid sick leave as opposed to unpaid sick leave, which exists throughout kind of the rest of Canada. So big change out of British Columbia, again, as of January 1st of this year. Flipping back to Ontario for a second, we've got some pretty significant changes to the Occupational Health and Safety Act. The first change that I want to talk about came into effect as of July 1st of this year, and that's a significant increase to fines for breach of the Occupational Health and Safety Act. So we saw the individual fine rise from $100,000 to $500,000 as of July 1st, as well as a new fine being created for directors and officers of companies who violate the Occupational Health and Safety Act of up to $1.5 million. So with these changes, the government is really signaling a huge focus and stress on the importance of health and safety in the workplace. So definitely want to make sure that you're in compliance there. Another change that I just thought was kind of fun and interesting is that the owner of a workplace must ensure that access to a washroom is provided to delivery persons and couriers. So that might seem like a little bit of a weird change to the Occupational Health and Safety Act, but it follows a pattern that we're starting to see of the government becoming more concerned with gig workers, workers that are in those more precarious employment roles and are traveling to and from various places and may not have access to a washroom otherwise. So another interesting change out of Ontario. Finally, in Saskatchewan, effective January 1st, we actually had a number of significant changes to the Saskatchewan Employment Act come into effect. One of the most notable changes is a new general section titled Protection from Liability, Reemployers and COVID-19 Measures. And basically what this says is that no action can be brought against an employer if the employer acted or made a good faith effort to comply with their COVID-19 requirements that were in effect at the time, and they did not engage in any conduct that would constitute gross negligence. So basically, if an employee was sick, they contracted COVID-19 while in the workplace, and that led to maybe sustained illness or disability, that employee is not going to have a right of action against the employer as long as the employer complied with their legal obligations. Finally, really quickly, I just want to talk about some upcoming changes in Ontario and beyond. All of the Ontario changes arise from Bill 88, the Working for Workers Act 2022. Just a couple of really interesting changes that we can expect to see in the future. The first is an exemption from the Employment Standards Act for business and IT consultants. So as of January 1st, 2023, the ESA is not going to apply to business and IT consultants where certain criteria is met. And that criteria is basically that they're incorporated or that they're a sole proprietorship and that they're earning a certain amount of money per hour. And that threshold is $60 per hour. So if both of those conditions are met, this group of employees would be exempt from the application of the Employment Standards Act. We're also going to see two new regimes created. The first is a licensing regime for temporary help agencies and recruiters. So basically, temp help agencies and recruiters are not going to be able to operate in Ontario without a license. This probably is not going to come into effect until 2024. Those are kind of the whispers that we're hearing on the street. And then the second regime is the Digital Platform Workers' Rights Act. And that kind of goes along with what I was saying is of an increased interest and focus on providing protections to these gig workers. And so basically the purpose of this act is going to be to set out basic rights for individuals who are working through a digital platform, such as a ride sharing or delivery app. These rights are going to be similar to the rights that are provided to employees under the Employment Standards Act, but much more watered down, right? So we're going to see some minimum wage requirements. We're going to see some entitlements on termination of a relationship, but to a much weaker scale than what we see under the Employment Standards Act. So we'll keep our eyes out for that. An amendment coming up to the Occupational Health and Safety Act is the requirement for employers to have naloxone kits in the workplace if an employer is aware or ought reasonably to be aware that there could be a risk of a worker having an opioid overdose. So again, not yet in effect, but something that is going to come into effect on a date in the future. So we'll keep our eyes open for that. And then really quickly, upcoming changes at the federal level. We've got two interesting changes that are coming up. The first is the implementation of 10 days of paid personal leave under the Canada Labor Code. So as of December 31st of this year, federally regulated employees who have been employed for at least 30 days will have access to 3 days of paid sick leave. As of February 1st of 2023, they're going to acquire a 4th day. And then they're going to continue to accumulate additional days every month up to a maximum of 10 days per year. Now, what's interesting about this is that these days are actually going to be able to be rolled over as well. So they can roll over into a subsequent year if they're not used, but anything rolled over is going to decrease the amount that they can earn in that year. So basically, there's no way to have more than 10 paid sick days under the Canada Labor Code. And then the final requirement or new change I want to talk about is an amendment coming up to the Competition Act, which is going to be in effect as of June 23rd, 2023. What this change is going to do is create a new criminal conspiracy offense under the Competition Act for employers who enter into wage fixing and no poaching agreements with other unaffiliated employers. So basically what this is going to do is prohibit unaffiliated employers from having agreements that fix or control salaries or terms and conditions of employment, or prevent unrelated employers from being able to solicit each other or steal each other's employees. The penalty for violating this provision is actually going to be really, really high. It's up to 14 years in prison or a fine to be set at the discretion of the court, which means there's no limit on the fine. So that's a really, really significant, both of those are very significant penalties. And these are changes or is a change that could have a really significant impact on employers and is going to require them to look at not just their employment agreements with their employees, but also agreements that they might have with other employers, other businesses. So I would encourage you guys to keep your eye on our various blogs as well as our newsletter for more information about these and other changes coming in 2023 and beyond.
Great. Thanks, Brittany, for covering a whole lot and giving us a good reminder that you can't just go by what the headlines say, because as an example, the right to disconnect is not really a right to disconnect at all. So again, I know I've said it a few times, I know it sounds self-serving, speak to an employment lawyer, don't just go by what you've heard or what you see in the news. So before we get to our last presentation of the day, I do want to remind everyone, if you have any questions, use the Q&A box. We do hope to have some time at the end to answer a few questions, so please send them in that way and we'll get to as many as we can. But before we get there, it wouldn't be complete without an update on the COVID-related cases, which are starting to make their way through courts, tribunals, grievance arbitration, et cetera. So we have Jeffrey Lowe who's going to bring us up to date.
Thank you, Stuart. Yes, and as we've been discussing, the COVID pandemic is starting to largely appear in the rear view, and we're dealing with the legal implications of the changes that were made during the pandemic to essentially allow things to continue moving forward. A number of questions remain unanswered, but we're starting to get some insight from the courts on a couple of the more substantial questions, which we're going to talk about today. So let's go with the first one. Slide, please. Thank you. So the first question is it a constructive dismissal for an employer to place an employee on an unpaid leave of absence for refusing to comply with a mandatory mask mandate? And the first case I'm aware of that's addressed this is Benke and Loblaw Companies Limited, which is an Alberta Court of Queen's Bench decision. Really quickly, Mr. Benke is was about a 20-year employee of Loblaw in a very senior role. He was responsible for overseeing approximately 60 produce and flower departments in Alberta and British Columbia. The employer implemented a national mask mandate requiring that every one of its employees, including Mr. Benke, wear a mask while at work. Mr. Benke had a medical condition which made it uncomfortable for him to wear a mask, but his treating physician could not provide him with a specific exemption to excuse him from having to wear a mask in the workplace. And as a result, he was placed on an unpaid leave of absence. The employee, Mr. Benke, sued, claiming that the leave of absence was a constructive dismissal and therefore he was entitled to reasonable notice. This was brought before the court, which is addressed on the next slide. Could I get the next slide? Oh, thank you very much. So the court found that masking was an essential part of the employment relationship and that the policy requiring employees to wear a mask was not a substantial change to the terms and conditions of the employee's employment, and therefore this was not a breach of the employment relationship. The court went on to find that the unpaid leave of absence was a substantial change to the employment relationship, but not sufficient to create a breach in the employment relationship such that there was no constructive dismissal. The court went on to note that it was Mr. Benke's ultimately his voluntary choice not to comply with the employer's mask mandate, the consequences of which was that he was not able to work. And the court noted that if he wasn't working, he would not be entitled to compensation, and therefore it was a legitimate thing for him to be placed on an unpaid leave of absence. This is a relatively recent decision. It's not clear if it's going to be appealed or not, but this is where the law stands currently in Alberta, at least in this respect. What about vaccines? I can hear the crowd asking, what about vaccines? So let's talk about vaccines. So the first case involving whether or not being placed on an unpaid leave of absence for refusing to comply with an employer's mandatory vaccine policy is Parmar and Tribe Management, Inc. I know this is the first case because the court indicates as much. It's a remarkably self-aware decision. The court, in the first paragraph or so, the judge writing the decision notes that this is the first time this has been addressed civilly, which from a legal nerd perspective is kind of neat when the court refers to itself. So this is an individual, again, Ms. Parmar like Mr. Benke, was a relatively senior employee, had been with the company for about 19 years. The company, not that it's terribly material, but the company had been purchased. Her employer had been purchased by a separate company, and her employment continued throughout. The employer had been working on a remote basis for quite some time and decided that due to decreased productivity from the remote work environment, it was going to start calling people back to the office. The employer performed a risk assessment before doing so to determine if its workforce was especially susceptible to COVID, and determined that a number of its employees had in fact been affected by COVID. There was one employee, in fact, who had been vaccinated, but had nevertheless caught COVID and had been sick for about 4.5 months. And so it determined that it was necessary for all employees to be vaccinated before returning to work. It advised everybody that they would need to be vaccinated by November 24th. It sent this missive out at the start of October. The employee immediately objected and advised that she had performed her own research in terms of reviewing medical information and observing her own family members' reaction to the vaccine, and determined that the vaccine was not safe and she was concerned about the side effects and refused to get vaccinated. She proposed a number of alternatives to the employer. The employer refused every one of them. And as a result, she was placed on an unpaid leave of absence as of November 24th, 2021. The employer kept her job open, but all she had to do was get vaccinated, but she did not, and ultimately took the position she had been constructively dismissed. When this came before the court reviewed the employer's mandatory vaccine policy. Sorry, can I change the slide, please? I forgot to say. Thank you. When it came before the court reviewed the employer's mandatory vaccination policy and the basis for its assessment, and determined that the vaccination policy was a legitimate one and a reasonable change to the terms and conditions of employment. The court took judicial notice that vaccines were safe and effective, and ultimately that it was a legitimate, and this added to the legitimacy of the mandatory vaccination policy. The court found that no constructive dismissal had taken place, noting that a reasonable employee would not have seen being placed on a leave of absence as a substantial change to employment. As its basis for doing so, the court noted that everybody else at Tribe Management Company had been vaccinated apart from the plaintiff and one other employee. And the court also noted that the vast majority of adults in Canada had been vaccinated as well, and essentially deemed that a reasonable employee in the employee's position would have found that a leave of absence was a legitimate response to her refusal to comply with the employer's mandatory vaccination policy. So that's masks and vaccines. Let's talk about the infectious disease emergency leave. What about the infectious disease emergency leave? I can hear everybody asking. So the question, and just to backtrack, the infectious disease emergency leave was a change to the Employment Standards Act implemented in Ontario during the pandemic, which indicated that an employer could reduce an employee's hours of work and income to as low as 0 in response to a COVID-19 related matter. The question was whether or not this constituted a constructive dismissal at common law. The change to the statute indicated that it would not be constructive dismissal for purposes of the Employment Standards Act, but whether or not it was constructive dismissal for purposes of the common law remained out there. Almost immediately, there were cases heard on this. There have been 3 cases addressed to my knowledge so far. 2 cases say that, yes, it is constructive dismissal to be placed on the infectious disease emergency leave. This is Coutinho and Ocular Health, and Fogelman and IFG. There was 1 case which said that it was not constructive dismissal, which was Taylor and Hanley Hospitality. Just as an interesting kind of distinction between the two, in the first 2 cases, Coutinho and Fogelman, the individual whose employment or who had been placed on idle, their employment with the employer had ended as a result of this, whereas in Taylor, the individual was only off work between March and September of 2020, and so therefore was suing to determine if they had an entitlement in the first place for the 6 months they were off, and if so, what that entitlement was going to be. At trial, or actually on motion, I guess, the matter was found, the employee was found to not have been constructively dismissed, and the court noted that essentially desperate times call for desperate measures, and it was a legitimate response. The idle was a legitimate response to the pandemic. This was appealed. The appeal was heard in April of 2022 and released, I believe, May 5th, 2022. It was a big day at Rudner Law. Everybody was refreshing their screen. I certainly was, waiting for this decision to come in. to determine whether or not there was a final assessment if idle in fact constituted constructive dismissal. The Court of Appeal, instead of providing an answer on this, indicated that the original decision had come before the court on the incorrect rule of civil procedure and kicked it back down to the lower court to be addressed again. There was a paragraph or two in the decision explicitly stating that I know everybody wants us to rule on this, but we're not going to because we haven't been briefed. So essentially, as it stands, 2 cases say that being placed on idle is constructive dismissal. 0 cases say it's not, but none of these cases are appellate decisions, and none of these cases address a layoff from the conventional sense of the term rather than a dismissal. So what it is out there. So where are we? Next slide, please. Thank you. So where are we? If you look at Benke and Parmar, if a mask or vaccine mandate is reasonable, then placing an employee on leave may not be a constructive dismissal. But to be abundantly clear, these are both very fact-based analysis and are outside of Ontario. So it's not necessarily going to be binding on, it's not even necessarily going to be binding in Alberta or British Columbia. These are going to be persuasive as opposed to binding. In that respect, in Ontario, these are going to be persuasive in that a judge can take them into consideration when making their decision on a similar fact pattern, but are not going to hold the field. So a judge is going to be able to determine whatever the judge deems necessary in terms of the outcome. In addition, there hasn't been any appellate judgment on these respects as well. In terms of idle, nobody's abundantly clear. I think we're going to see a number of additional decisions. I know a lot of lawyers were holding back on proceeding with an idle case pending Taylor's appellate decision. When Taylor was punted back to the lower courts, the decision was made to proceed. I know at least one lawyer who's bringing a case forward just from speaking to lawyers in my practice. The big questions kind of remain unanswered, primary of which is it just cause to dismiss somebody for refusing to comply with a vaccine or mask mandate? I think a number of people were dismissed for this throughout the pandemic. I know I've certainly spoken to people on both sides of my my practice where this has happened, or they've had to dismiss somebody for refusing this. The outcome of this remains up in the air. I think it's going to come in the immediate future. We will definitely blog about it. So if you're interested in this subject matter, please keep refreshing our newsletter and keep checking our blog. And back to you, Stuart. Thank you.
Thanks, Jeff. That was great. You can really hear the disappointment in Jeff's voice that the Court of Appeal decided not to address this issue that we're all waiting for. But at some point, this will be addressed. And I think, as Jeff made pretty clear, it depends. You know, there is no one rule that's going to apply to everyone, but we're going to have courts looking at fact-specific analysis as they usually do. So as Jeff said, stay tuned. So before we get to some cute question and answers, we did promise everyone a free gift if you tune into the webinar. So what we're offering is 10% off of a starter package. And then for those of you who don't know, we have a number of what we call starter packages, which basically provide contract templates, policy handbooks, guides to legislative requirements, and more for a fixed fee. So we'd be happy to tell you more about that. But as a bonus for those of you who tuned in today, we're offering either 10% off of that, or if you have something else that you need help with, 10% off of your first invoice. So you need the secret code to get that, which hopefully I can bring up here. I have asked Mel Brooks of Spaceballs to share the code.
Three, 4, 5. So the combination is 1, 2, 3, 4, 5.
Yeah, I just want to go on record. That is the same code as my luggage.
Now you're gonna have to change the code or buy new luggage. So just in case, I don't know if the audio was good. So just in case anyone didn't catch it or doesn't remember Spaceballs, the secret code is 1, 2, 3, 4, 5. And as it says on the slide here, this offer is good until March 31st, 2023. But we'd be happy to help you and offer that to you. So thank you for tuning in. We do have a few minutes for questions. And the first one we wanted to get to is really the question we've been answering in one form or another for months now. So it was sent in by an anonymous attendee, and I may paraphrase somewhat, but essentially it's that we have an employee that refuses to come back to work, citing a phobia to COVID. They don't want their mother to get it, although their mother is fine and healthy. We know this employee has mental health issues and that they are personally dealing with. Working remote was only offered during the first outbreak of COVID as temporary. This employee refuses to come back. We don't know what to do as they are producing and remote is not working. So I'm not sure if that says not or should be not producing. Work has been offered in office, yet they refuse. So I think Nadia, you were going to take a first crack at that.
Yes, thanks, Stuart. And thanks for whoever sent in that question. That's a great question that we've helped many of our clients with. Now, an employee cannot refuse to return to the office unless they have an existing right to work remotely, they're refusing unsafe work, or if they have a legitimate need for accommodation based on a protected ground under human rights legislation, such as disability or family status. Assuming that there's no right to work remotely here, you will still have to consider whether the employee has a legitimate need for accommodation based on a protected ground under human rights legislation. If the employee says there's a need for accommodation, you can ask them to provide evidence that's reasonable in the circumstances, which may include a doctor's note. If it's simply a preference, you don't have to agree to allow them to work from home, but if it's a need, you have to consider accommodation options. Employers have the obligation to accommodate employees up to the point of undue hardship, which is a high threshold to meet. I strongly recommend seeking legal advice regarding the specific situation, so your employment lawyer can advise you accordingly, and we'd be happy to help as well.
Great, thanks, Nadia. I mean, and we're seeing this all the time, as we've said, and I think it gets back to a point you made in your presentation, which is, by default, the employer has the right to decide where somebody works, unless there is an explicit or implicit contractual right, then you can insist. But the longer you let somebody stay at home without making it very clear that it's temporary, the more likely it is that they are essentially there's going to become an entrenched right to remain working at home. So you need to be very careful about communication. So I did want to take one of the questions that came in from Jabin. What if the company is located in Ontario, but some employees are working remotely from Quebec? Will we still need to provide employment agreement in French language? So I'll answer this from a bigger picture because we're seeing this all the time as well. It sounds great when someone realizes they're working remotely and doesn't have to be in the same city anymore. They can move somewhere less expensive, somewhere more exotic. There's a great article last week about people secretly working from Caribbean islands and that kind of thing, which sounds amazing. But what we need to remember is that at some point, if someone is permanently moving somewhere else, then the employment standards laws which apply will be those in the jurisdiction that they are now working in. Different if it's temporary. If they work in Ontario, but they're going to take a month in Quebec or even a few months in Florida or something like that, that's one thing. But if they are permanently relocating or if they never were in the jurisdiction, just because the office is in Toronto, if they work in Vancouver, they're governed by the laws of British Columbia. So you need to be very careful about that. And as well, there may well be tax considerations to be mindful of. So be very cautious. And we're putting wording in our contract templates now, which requires that the individual advise the employer before moving out of the jurisdiction, just to control that kind of thing as much as we possibly can. So I think we had time for one more question, and I may have got this wrong. Brittany, I think you were going to take this.
Yes, this is a question from Andrea Feldman. The question is there a need for accommodation related to a situation that the employee's spouse has medical issues and they feel it might affect them if they come back to work? This is a really, really good question because, as Nadia has mentioned, there is a duty to accommodate, and we're typically thinking about this in the context of the employee has a specific need for accommodation. So they have an illness or disability that is making it difficult for them to return to the office. So the question here is, what if it's not the employee? What if it's their spouse that has a medical condition that makes it difficult for the employee to come back to the workplace? And the answer is that this could still fall within a protected ground, right? There is a protected ground of family status, where a worker has responsibility for the care of or is living with somebody who has a potential disability. There could still be a duty to accommodate. But as Nadia mentioned, this is not based on a preference. This is based on a legitimate need. And as the employer, you are entitled to request supporting documentation or supporting information regarding the request that supports the request or need for accommodation.
Great, thanks, Brittany. And I know we're now at 1 o'clock exactly, so we couldn't get to any more questions, but we'll try to get to some either on our blog or on my monthly online show, Fire Away. So we'll try to get to your questions, or feel free to email us as well. So I want to take the time now just to thank everybody for tuning in, also to thank my entire team, both the people that you met, but also the people behind the scenes, in particular, Mary Cadrick, our office administrator, who organized all this and made sure it all went smoothly. And I just want to remind everyone that, as we've said, we work with employers and employees. And one thing that has not changed in my 23 years of practice is that people tend to act without fully understanding their legal rights or obligations. So, and it's the same for employers and employees. They make assumptions, then they make decisions, and then they often spend a lot more money and a lot more time fixing the problems rather than having them prevented in the first place. And as Nadia said earlier, it's a perfect example of being penny wise and pound foolish. So what we want people to do is to treat their employment relationships like legal relationships. You might be hiring someone or starting a new job. We look at you as starting a new legal contract. So we want you to make informed decisions, which is why we do sessions like this, which is why we contribute frequently to our own blog, as well as several other blogs, why we have very active social media. We have my monthly online show that I mentioned, Fire Away. By the way, if you have any ideas for topics for Fire Away, please email us. And we also encourage you to sign up for the newsletter. But as we always say, and Nadia already said it, none of that replaces legal advice. So if you think you might need an employment lawyer, you probably do. Feel free to reach out to us. And the last thing I will say, one thing that I think distinguishes us from a lot of law firms, we really like to get away from the billable hour as much as we possibly can. Things like the starter package that I mentioned earlier, we do on fixed fees. We also do other project-based fees. We're also starting to work on retainer or subscription arrangements, with the purpose being that we don't want people to be scared to call or email, because that's often the answer we get. When we ask someone why they didn't call us before they did something, they'll say, well, I didn't want to have that cost. So we're trying to set up ways that people can call us, get the advice they need proactively, as opposed to having to clean up the mess later and spending a lot more money. So I will encourage all of you to reach out to us if you have questions, connect with us on LinkedIn and on other social media. And I'll mention as well, I have a group on LinkedIn called Canadian HR Law. We have, I believe, over 18,000 members at this point. And it's a great place to go and ask questions. And you'll get answers from employment lawyers, colleagues in HR, business people, and anybody else. If you want a copy of the slide deck, feel free to send us an email. The recording of this session will be posted on our YouTube channel, probably on our website as well. And I think that's about it. So thank you everyone for tuning in. Thanks as well to my entire team, and have a great rest of the day.